So good evening, everybody. Thanks for joining us. And here we are going to finish off part 3 of How Wealth Rules and then move into part 4, and hopefully we'll complete that tonight. But there were just a few sections left not covered from part 3 last month. So diving right in. And again, welcome everybody. And before I dive right in, are there any questions or any concerns about what we covered last time? And I'll give a little bit of a recap of what that was. But did anything stand out that you needed to have clarified, or any questions or concerns? Seeing none. All right. So last month in part 3, we covered the enclosure movement, the enclosure of the commons, the privatization of land and resources, the attack on natural communities and unindentured subsistence populations. And we also covered Tom Paine, the commoner who explained the systemic injustices of aristocracy and monarchy and empire, and he triggered a revolution in America. Today, I'll finish up part 3's coverage of the ongoing counter-revolution and move on to part 4, which is titled Of Laws and Men. So we know that Tom Paine, I say a commoner, so he was kind of working class background. He catalyzed the American Revolution with his Common Sense pamphlet by dissecting the British class system and the legal system to show that it doesn't have to be that way. I talked about his other publication, Agrarian Justice, and how it suggested a solution to the enclosures and an end to monopoly control of land by the wealthy. He gave farmers and day workers and shopkeepers hope for a new world in which liberty and basic rights formed the foundation of government. But what motivated the wealthy members of colonial society to take up arms and defy the empire? People like Washington and Hamilton and John Adams, what was in it for them? And that's part of what we're going to cover here to wrap up part 3. The first subheading in that chapter is titled, I Cannot Tell a Lie, Washington's Hidden Agenda. Begin with the contrast between the attitudes about property and land between the revolutionary Tom Paine and Federalist George Washington could not be starker. Washington, the purported father of our country, treated neither commoners under his military command nor squatters on land he claimed to own with much paternal concern. He acquired much of his land holdings by buying up promissory notes issued to colonial infantrymen under his command during the French and Indian War. During that war, Washington was a British officer. The land grants were issued by the Virginia House of Burgesses in payment for their military service. Before the Revolution, those lands were part of the Virginia colony, and Washington was a member of the House of Burgesses. Washington urged his men to sell the notes to him because he said the script was unlikely to be honored after the war. The soldiers, short on hard currency and in debt for unpaid taxes on the land that they farmed, had little choice but to surrender their claims. But contrary to Washington's allegation, the House of Burgesses did honor the script at the end of the war. With tens of thousands of purloined acreage now in his possession, Washington's fortunes seemed assured. Now, whatever motivated Washington to throw in with the American revolutionaries to wage war on Britain, part of the calculation must certainly have been the Royal Proclamation of 1763. With it, King George III revoked land grants west of the Appalachian Mountains to make peace with the Native Americans and avoid the expense of military protection for settlers in the region. As a result, Washington's property claims were rendered worthless while the British ruled. The fate of Washington's land claims would rise or fall on the success or failure of the revolution. With victory in hand, he employed agents to secure his claims. They evicted homesteading dirt farmers who had cleared land and built homes. Then Washington put plans in motion to open his frontier holdings to the extraction of resources by building a canal. And that's the end of the first subheading. Any questions or comments on that? Okay, I'll move on to the next section titled "The First Law Adopted to Subordinate Democracy to Corporations Was the U.S. Constitution." James Madison, George Washington, and a cadre of fellow investors were itching for a man-made waterway that would open the frontier. They each had claims to large swaths of land in what is now western Pennsylvania and eastern Ohio. Their proposed canal would run parallel to the Potomac River along the Maryland and Virginia borders. To build it, they needed permission from the people of both states to charter a corporation that would oversee and finance the project. The Articles of Confederation, the then Constitution of the United States, reserved the chartering of corporations to each of the state legislatures. Washington and his partners would have to get the approval of Virginia and Maryland for the proposed Potomac Company to become a reality. Chartering corporations was not taken lightly prior to the American Revolution. The revolution had been waged as much against the empire's largest chartered corporation, the British East India Company, as against the empire itself. It was the East India Company's tea that was famously dumped into Boston Harbor. If the Potomac venture was to succeed, both states would have to independently agree to enact legislation chartering the desired company. Well, it took 10 years for the Potomac Company investors to receive the go-ahead from both states. The entrepreneurs resented that inconvenience, so much so that they hatched a counter-revolutionary plot to overturn the first Constitution, the Articles of Confederation, and remove democratic control of commercial activities from state and local governments. The investors in the Potomac Company met in 1785 at Washington's Mount Vernon slave plantation. Their private discussions led to a decision to invite delegates from all the states to a convention the next year to be held in Annapolis, Maryland. The reason they gave for the meeting was to consider a uniform system of commercial regulation, quote, for their common interest and their permanent harmony. In 1786, they were disappointed to have delegates arrive from only 5 states: New York, New Jersey, Pennsylvania, and Delaware, and Virginia. That's delegates from those states attended. The Annapolis delegates drafted another note, and they sent it to Congress. And they requested a convention to be called for the following spring to consider improvements to the Articles of Confederation that would cover more than just commercial trade. Congress obliged, and on February 21st, 1787, adopted a resolution that read, quote, that in the opinion of Congress, it is expedient that on the second Monday in May next, a convention of delegates who shall have been appointed by the several states be held at Philadelphia for the sole and express purpose of revising the Articles of Confederation and reporting to Congress and the several legislatures such alterations and provisions therein as shall, when agreed to in Congress and confirmed in the states, render the federal Constitution adequate to the exigencies of government and the preservation of the Union. Historian Robert Schuyler commented that, quote, it turned out that in sanctioning the Philadelphia Convention, the old Congress was in effect signing its own death warrant. 70 delegates to the 1787 Philadelphia Convention were appointed by the state legislatures, although Rhode Island declined to participate. 55 of the appointed delegates made an appearance. The invitation didn't mention the Federalist plan to dispose of the revolutionary Articles of Confederation, Other than the counter-revolutionary conspirators, those who came were expecting to revise the Articles of Confederation, not overturn them. By the end of the convention, only 39 signed the recommended their handiwork to the states for ratification. The 14 who declined to sign, along with those who chose not to attend, including Richard Henry Lee, Patrick Henry, Thomas Jefferson, Samuel Adams, and John Hancock, all notable anti-federalists who opposed ratification of the Federalist document. And so, as kind of a summary of how the Constitutional Convention in Philadelphia came to be, and it originated with the investors in the Potomac Company to build a canal along the Potomac River in order to ship lumber and coal and other resources out of the lands that those investors had claimed. Any questions or thoughts on that? Okay, if not, I'll move on to the next section, which is the Constitution makes public law privileged property. And that privileged property is a term that we've been using that designates a kind of property that when a person comes into possession of it, it transfers certain legal rights and governing privileges to the owner of that kind of property. And corporations are a type of privileged property. So James Madison arrived in Philadelphia to the convention with a draft for a completely new form of government called the Virginia Plan. It became the blueprint for the Constitution that would replace the Articles. He had competition, though, from Alexander Hamilton, who arrived with his New York plan. It proposed a limited monarchy. Madison kept notes of the deliberations and recorded Hamilton's comments this way. He quotes Hamilton as saying, "I believe the British government forms the best model the world ever produced. It is admitted that you cannot have a good executive upon a democratic plan. See the excellency of the British executive. And let me observe that an executive is less dangerous to the liberties of the people when in office during life. I confess that this plan and also that from Virginia are very remote from the idea of the people. But the people are gradually ripening in their opinions of government. They begin to be tired of an excess of democracy." Well, that was Hamilton's opinion at the time. But certainly, as he grudgingly admitted, it was not the position of the people, the commoners, who had actually fought the Revolutionary War against the British Empire. John Dickinson of Pennsylvania, according to Madison's notes, believed, quote, "A limited monarchy is one of the best governments in the world. A limited monarchy, however, was out of the question. The spirit of the times, the state of our affairs, forbade the experiment if it were desirable." And so the question of whether or not there should be a monarchy put in place after the revolution was seriously discussed by the delegates in Philadelphia. And as John Dickinson, the quote reflects, he thought it was a bad idea because the commoners, the majority of the people in the colonies, would balk at the idea of reinstating a monarchy. In 1788, Madison confessed that, quote, "Among those who embraced the Constitution, there were no doubt some who were openly or secretly attached to monarchy and aristocracy. But there were no claims to noble birth among the colonial gentry." Charles Coatworth Pickney of South Carolina remarked that he did not, quote, "suppose that in the Confederation there are 100 gentlemen of sufficient fortunes to establish a nobility. If we have any distinctions, they may be divided into three classes. First, professional men. Second, commercial men. And third, the landed interest. The latter is the governing power of America, and the other two must ever be dependent on them." End quote. So it was that land became the first species of privileged property. The constitutional counter-revolutionaries agreed among themselves that property in land and in all the resources to be derived from it would be the best measure of the legitimacy of a man's claim to membership in the governing class.
3 weeks, they injected the mice in both groups with
Thank you. In the end, due to the spirit of the times, as Dickinson put it, the Federalists decided not to institute a monarchy and instead made wealth king. They accepted Madison's Virginia plan as their starting point and then haggled over the details through the sweltering summer. But 11 years earlier, Thomas Jefferson, inspired by Thomas Paine, had written eloquently in the Declaration of Independence that, quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their creator with certain unalienable rights," end quote. In the spirit of those revolutionary times, he altered the usual triumvirate of Enlightenment era rights, typically listed as life, liberty, and property, replacing property with the pursuit of happiness. It was this language and not the rhetoric of the Federalists that mobilized commoners to take up arms and risk their lives for independence from Britain. The aspirations of commoners who fought for liberty from the empire were abandoned when George Washington, James Madison, Alexander Hamilton, Robert Morris, and other wealthy Federalists crafted the current U.S. Constitution. Edmund Randolph of Virginia commented that the purpose for overturning the first Constitution was, quote, "to provide a cure for the evils under which the U.S. labored, that in tracing these evils to their origin, every man present at the convention had found it in the turbulence and follies of democracy." The 39 delegates who were motivated to sign off on the Constitution at the end of the convention agreed that the country could live without venerating royal privileges, but they concluded that reverence for a wealthy landowning class to which they all belonged was indispensable to good governance. And that is the end of part 3. They were the sections that we didn't quite get to last month. Any thoughts, comments, questions on part 3 or the tail end of it that we just wrapped up with? No? Okay.
It
Go ahead.
How did this just get left out of our history books? Our history books, not histories.
Well, you know, the information is out there, but you're right, it's not included in the history books. And we look at the times today and how books are being banned and how curriculum is being whittled down into milquetoast versions of history, which is false collective memory. I guess that it suggests that these aren't brand new ideas, that it's not a wholly new thing for those in power to try to sanitize the facts and the memory of the past. And to be fair, most nations on the earth like to point to some kind of a miraculous beginning for their nation, some founding story. And the founding story probably wouldn't hold much water in the US if we were talking about how the father of the country, the so-called father of the country, George Washington, and the so-called founding fathers who drafted the Constitution, but who were not in league with the revolutionaries who actually defeated the British Empire, telling the story completely in that way probably wouldn't serve the ends of inspiring patriotism and jingoism and the rest of it. I can sometimes flippantly say it feels to me sort of like the stories we tell children about Santa Claus and the Easter Bunny. While they're young, we say, "Oh, they're innocent. They can't handle the truth of it. So let's create some fun story for them to believe in. Well, the fun story that has been handed down to us about the founding of our nation has never been revised for adults in high school and college. Not to say that in college there aren't people who do research papers and the rest of it on these aspects, but of course they don't become popular history. They're just academic exercises. That's my perspective on it, at least. John, you're on mute if you were talking.
Oh, that always helps. I just have a quick vignette, I guess we'll say. I did master's for education at Lesley University, and I actually was interested. I actually had taught post-secondary, but I did 1 through 6 because of the very topic we're talking about. How is it we transition from telling first graders about Columbus discovering America to, of course, the invasion of this continent? And the real point I'm making here is rather sticks in my throat. Basically, the professor, there was the only course that was distasteful. Well, we're going to let the children, do web crawling and stuff and let them investigate. There was no real discussion about how we do what we do with regards to, the truth as was just spoken of. How do we do this? Wasn't even wanting to be entertained. Let's just, it's okay. Bye now, John.
Right. And the reality is that children are going to tend to believe their parents and the teachers that their parents send them into their care, and believe that they wouldn't lie to me about any of this. So why would they even begin to inquire and ask if it's the truth? Unless something occurred, some insight came into their minds that caused them to wonder. And frankly, that happened to me, which is why I bothered to dig in. But the thing is that the facts of the matter are scattered and not all in one place, which is, I certainly didn't do a complete job of, I'm not by profession a historian. So I cobbled together the information that I could and drew the connections that made sense to me. I've not yet come across a historian who has said plainly that Washington decided to throw in with the revolutionaries because if he didn't, his wealth in land would disappear as a result of the British having a treaty with the Iroquois west of the Appalachians that nullified land claims. 63,000 acres or so of land that he had a claim to, that he, and I'll just use the word swindled the men in his command out of, he would have lost it. Now, I have yet to see someone say, and that's why he said, I'm going to lead the military against the British. No, but when you consider those facts, and I'm not making that claim either because I don't have the smoking gun evidence to show it. What I do have is some suspicions and some questions and some wondering to say, do you think maybe that had anything to do with it? So I don't know. And I leave it to you, children, to do some further exploration. But at least the question's been raised. Okay, I'm going to move on and begin with part 4 of How Wealth Rules. And this is, again, coverage of my book, How Wealth Rules the World, Saving Our Communities and Freedoms from the Dictatorship of Property. And the comments I'm making pretty closely follow the book, but there are some departures and a little bit of differences. So it's not just about going through the text completely and exactly as it was published. But so I do encourage you to go ahead and read the book you want to dig into it and maybe pursue some of these ideas yourself. And by the way, should you find some really juicy information, I'd appreciate it if you'd share it with me because I remain curious. So I'm going to begin of Laws and Men in part 4, which is actually chapter 3, by the way, just for those who want to try to figure out with the numbering here. Part 1 of this series was the introduction. So part 4 of Laws and Men. And I begin with a quote, as I usually do. This is from Morris R. Cohen. And it's from an article that he wrote, Property and Sovereignty, from the book, Book, Law, and Social Order. And so the quote from Morris Cohen is, property and sovereignty, as every student knows, belong to entirely different branches of the law. Sovereignty is a concept of political or public law, and property belongs to civil or private law. This distinction between public and private law is a fixed feature of our law school curriculum. It was expressed with characteristic 18th century neatness and clarity by Montesquieu when he said that by political laws we acquire liberty and by civil law property, and that we must not apply the principles of one to the other. I think that you'll gather from my comments here that our legal system does just the opposite of what Morris Cohen argues should be done. So the first heading for part 4 is protecting the minority of the opulent against the majority. John Adams, that's our second president, argued that the United States is, quote, a government of laws and not of men, unquote. What laws? Well, the ones he and the property class devised. The Federalists were not authorized by the people to secretly deliberate over the text of a new constitution. Their wealth-protecting purpose did not reflect the general will of the people, and they knew it. James Madison at the Philadelphia Convention recorded himself saying this on Tuesday, June 12, 1787, quote, if the opinions of the people were to be our guide, it would be difficult to say what course we ought to take. No member of the convention could say what the opinions of his constituents were at this time. We ought to consider what was right and necessary in itself for the attainment of a proper government, end quote. Unsurprisingly, the Federalists diligently protected wealth from redistribution by peasant revolutionaries. They preserved English common law and made legal precedent into a judicial insurance policy against democratic innovation or redistribution of what once had belonged to no one, before the enclosures, before the conquest. Sir William Blackstone, the noted legal scholar of English common law, wrote that, quote, so great is the regard of the law for private property that it will not authorize the least violation of it, no, not even for the common good of the whole community. I'll say that when he uses the term private property, he's actually referring to what I call privileged property, not personal property. Legal precedent, when preserving this level of reverence for property, is nothing more than the rule of property that was weaponized into a forever legal tradition, guaranteeing that, as the rule of property is defined, quote, decisions under which property rights have been acquired will not be overruled, though erroneous. Even if property is taken erroneously, decisions under which those property rights have been acquired will not be questioned, will not be overturned. Thomas Jefferson argued against importing English common law into the American legal code because it justified an unequal class structure that American revolutionaries had rejected. Jefferson's warnings went unheeded. the Federalists were happy to retain the empire's common law, its judicial precedents. It added another layer of protection against, quote, the excesses of democracy, as the delegates to the Constitutional Convention were calling it. Those excesses of democracy that threatened to interfere with privilege for the wealthy. The scheme of government the Federalists proposed came as close to modeling the British system of lords and sirs as decorum would allow. Alexander Hamilton reluctantly agreed to drop his openly elitist New York plan that would have created a monarchy in all but name. He decided to back James Madison's Virginia plan. It proposed a less openly class-based constitution. It had the advantage of offering the superficial trappings of a republic that would be less objectionable to the masses. Hamilton commented that while the Constitution thus framed would not establish the limited monarchy preferred, the Virginia plan would be, quote, but pork still, with a little change of the sauce. In other words, it didn't actually create a monarchy, but it did come about as close as they could get away from. And yet today, there's a Broadway musical offering a popular rehabilitation of the memory of Alexander Hamilton. I don't know if anybody has seen it or seen a filmed recording of the musical. The music is wonderful. It's great. It's entertaining. And the storyline, again, is entertaining, just as the storyline of the founding of the United States is entertaining. It just doesn't happen to be true. A century later, a century after the Constitutional Convention, historian J. Allen Smith wrote that U.S. law, by endowing property with the ability to convey rights, quote, has given to the minority a greater protection than it has enjoyed anywhere else in the world, save in those countries where the minority is a specially privileged aristocracy. This doctrine, briefly stated, is that property rights, once granted, are sacred and inviolable. A rigid adherence to this policy would disregard the fact that vested rights are often vested wrongs. A government without authority to interfere with vested rights would have little power to promote the general welfare through legislation. And so we can see that there's a tension being built, that was being built by the Federalists, between rights in property and the democratic rights of the people to govern themselves or through representations, be represented and be governed in a Republican form. At the convention in Philadelphia, Madison told the rest of the delegates that, quote, if elections were open to all classes of people, the property of the landed proprietors would be insecure. Our government ought to secure the permanent interests of the country against innovation. Landholders ought to have as a share of the government to support these invaluable interests and to balance and check the other. They ought to be so constituted as to protect the minority of the opulent against the majority. And so wealth needed to be protected against democracy. In the mind of James Madison and apparently others among the Federalists, quote, the permanent interests of the country, unquote, meant the interests of the property class. And so that was how it came to be that we actually have a constitution that it's not obvious to all of us, especially those of us who took history classes that didn't spend much time asking such difficult questions about the Constitution as, why is it so focused on commerce? Why is it so focused on contracts? Why is it so focused on property? Why is it so focused on human property in slaves? And the explanation is that the Federalists who drafted the Constitution were interested in protecting rights in property much more so than rights in people. And so the argument against having all classes of people having the authority to vote was a decision made by those Federalists. Women were not included, blacks were not included. Indentured servants or slaves were not included. Native Americans were not included. I'm going to move on to the next section, but if there are comments or questions, go ahead, we'll take a couple.
Ben, I was just wondering, you differentiated the type of property, so privileged property you mentioned. Would we call that corporate law today?
Corporate law, I would say, is a species of privileged property. And as I said last time, the enslaved Africans were a species of privileged property, because when someone comes into possession of privileged property, it conveys to the owner, not to the property, not to the human chattel, but to the owner of that type of property. Legally, it was recognized as property. It conveys to the owners certain legal privileges, and the 3/5 clause was the tool that actually enacted that gave to the people who claimed ownership of human beings, gave them extra representation in the House of Representatives and in the Electoral College, because the 3/5 clause counted their enslaved human property as 3/5 of a human being in the census, and therefore increased their representation in the House of Representatives and in the Electoral College, because the representation was based on proportional representation.
I just really quick, I have, kind of foggily here, I read through something rather, I guess, technical enough to not remember all the terms. Katharina Pistor, the Code of Capital, if you're familiar.
Yes, I'm familiar with it.
Yeah. So she actually now has, and I just saw this the other day, coincident with seeing your program. So she has quite a bit, just as a note for folks, about how capital is coded, so to speak. So assets are protected through this corporate law. I may not have that quite right, but
no, you have it right, and I recommend the Code of Capital for anyone who's interested to understand a bit more about how does, and she doesn't use the term privileged property. That's my term.
That's why I'm asking. That's right.
Yeah, but she is, her code is the privilege bearing law that turns over governing authority to those who own this kind of corporate property, or wealth, not just corporation, but wealth in the form of a corporation.
Or any capital.
Or capital itself.
Capital could be a sentence I made.
Right. So I do recommend that folks read the Code of Capital as kind of an addendum to what I'm talking about here.
Thank you.
So I'm going to get into the next section in this chapter, and the heading is called the North American Free Trade Agreement of 1789. Didn't know we had a free trade agreement that early on, did you? With Washington presiding over the Constitutional Convention in Philadelphia, the Federalists from the northern states proposed a mechanism that would block commoners and their elected representatives from getting in the way of wealth accumulation and empire building. It comes down to these few words known as the Commerce Clause. Quote, Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. A constitutional prohibition against popular governance of interstate and international commerce comes later in the Constitution, where it says, quote, no state shall, without the consent of Congress, lay any imposts or duties on imports or exports, except what may be absolutely necessary for executing its inspection laws. And the net produce of all duties and imposts laid by any state on imports or exports shall be for the use of the Treasury of the United States, and all such laws shall be subject to the revision and control of the Congress, end quote. The Northern framers accomplished their primary goal in jettisoning the Articles of Confederation and drafting the U.S. Constitution. They established what today we might call the first North American Free Trade Agreement. And if you recall, it was the investors in the Potomac company, the corporation to build that canal along the Potomac, they're the ones who initiated the conventions to overturn, or at least initially the idea was to revise the Articles of Confederation. And what is it that they wanted to put in it? Essentially, the Commerce Clause that would override the authority of the states and local governments to have anything to say about trade that was between the states or other nations or native tribes. In other words, they wanted to create this free trade zone among the Confederation of Independent States. The Northern framers accomplished that with the Commerce Clause. By 1825, Thomas Jefferson was alarmed enough by the federal government's use of the Commerce Clause to nullify the state's lawmaking authority that he wrote in a letter, quote, "This will contain matters not intended for the public eye." He was writing at the time to a friend, William Branch Giles. This was in December of 1825. Continuing his quote, "The federal branch of our government is advancing towards the usurpation of all the rights reserved to the states under the power to regulate commerce and aided by a little sophistry on the words general welfare, a right to do not only the acts to effect that which are specifically enumerated and permitted, but whatsoever they shall think or pretend will be for the general welfare," end quote. That same letter went into more detail, accusing the Supreme Court, the President, and Congress of conspiring to, quote, "strip the states' authorities of the powers reserved to them," unquote, to favor the largest industries over the smallest, and to cut down mountains for the construction of roads and canals for private interests. Then he asked, quote, "Are we then to stand to our arms?" End quote. He decided the time would be right, quote, "only when the sole alternative left are the dissolution of our union with them or submission to a government without limitation of powers. Between these two evils, when we must make a choice, there can be no hesitation." Now, Jefferson was an old man at the time, and I still criticize him because he did nothing. I was called to task on that. Well, he was too old to do anything. I said, well, doing something would have been not making this a secret letter, but actually leaving it out for the public to decide for themselves. And so he was saying that the Commerce Clause was being used in a way that might call for the dissolution of the Union, because it was now working against the democratic interests of the majority. Commandeering oversight of commercial activities from state and local governments is justified to this day by claiming centralized regulation serves the general welfare. Even the most tenuous claim that a public act crosses a state border is enough to elicit claims that a national interest is involved. Usurpation of the majority's governing authority on this basis is, thanks to the Federalists, both constitutional and legal. Here's an example. In 2001, the U.S. Supreme Court ruled on a case involving a challenge to Waste Management Holdings and the owners of a landfill in Brunswick County, Virginia, against the governor of Virginia, the Secretary of Natural Resources of Virginia, and the Department of Environmental Quality, the DEQ. At issue were 5 state laws enacted in 1999 to limit the importation of waste from outside of Virginia for dumping in privately owned landfills. About 30% of all waste disposed of in Virginia comes from out of state. In 2011, a report noted that, quote, waste arrived in Virginia last year from 24 states and several foreign countries, including Canada, Mexico, and others in Central and South America, end quote. The lawsuit against Virginia's laws charged that they violated the U.S. Commerce Clause. Congress had never ruled waste to be a commodity or a matter of commerce, but the Supreme Court had, by the time of this litigation, expanded the meaning of the Commerce Clause so that it not only reserves to Congress exclusive power to regulate trade across borders, but also, quote, restricts the powers of states to regulate or impose burdens on interstate commerce, and in the absence of congressional approval, invalidates regulatory measures designed to benefit in-state interests at the expense of out-of-state interests, end quote. For all of human history until this ruling, what to do with waste had been a matter of local community discretion. But canny investors saw opportunity in moving urban waste out of one jurisdiction and into another. They had law on their side, and the unlucky receiving communities did not. So this revision of the Commerce Clause, called the Dormant Commerce Clause, by the Supreme Court, made it so that if commerce says that it's commerce, it is commerce. And even if it doesn't say it's commerce, the Supreme Court might say that it is. As a result, every municipality, rural village, and urban metropolis is subordinate and supine before the juggernaut of the Federalist constitutional mechanisms for protecting wealth and the property class from obligations to community priorities. The diversity of lobbyists and industry front groups that have referred to local community lawmaking that conflicts with their business plans as, quote, a patchwork quilt of regulation. Well, it's amusing but disturbing. The presumption is that the public has no legitimate role in defining or governing production, labor, and finance. Private law, including the Contracts Clause and the Commerce Clause, ensures the separation of wealth and state. Everything from privately owned fossil fuel pipelines, trucking, trash hauling, telecommunications, retail chains, copyrights and patents, banking, food production, medicine, alcohol, tobacco, and firearms, you name it, has been declared an issue of interstate commerce and removed from state and local control, that is, governance by the people. The law chooses winners based on wealth. The losers are derided as NIMBYs, that is, not in my backyarders. In recent times, this ploy of invoking the Commerce Clause for the general welfare has come to include issues with doubtful relevance to interstate commerce. Here's an example that at first blush may seem a welcome invocation of the Commerce Clause, where the general welfare was protected. Under intense political pressure from the streets in the 1960s, a reluctant Congress enacted laws against racial discrimination. Lawmakers declared that they had authority to regulate how business operating in multiple states treat minority customers. In Kazensbach versus McClung, the Supreme Court, that's 1964 was the case, the Supreme Court upheld Congress's authority to ban racial discrimination in restaurants because it is a burden to interstate commerce. Instead of treating bigoted business policies as violations of constitutional rights, the federal government found it easier to categorize racial discrimination as a regulated component of commerce. One reason for relying on the Commerce Clause to regulate rather than eliminate racial injustice by businesses goes back to a watershed court case that exempted wealth from public law prohibiting Bill of Rights violations. So here's a little quick aside about that law. Back in 1875, the Civil Rights Act was passed by Congress, banning racial discrimination by the hospitality, transportation, and other industries. Unhappy business owners brought a series of lawsuits against the act, claiming that Congress has no authority to regulate their treatment of customers. 8 years later, the U.S. Supreme Court bundled and reviewed those cases in what's called the Civil Rights Cases of 1883. To reach its conclusion, the 8-to-1 majority interpreted the post-Civil War 14th Amendment to the Constitution in a way that had the effect of amending that amendment. As ratified, the 14th Amendment reads in part, quote, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws," end quote. All but Judge John Marshall Harlan concluded that the 14th Amendment forbade states from passing discriminatory laws, that it gave no power to Congress to impose accommodating treatment of patrons on private businesses. The ruling declared business and corporations to be private in nature. Even though the 14th Amendment prohibited states from making laws that violate the privileges or immunities of citizens, the court determined that business entities created by state chartering and licensing laws were not, quote, state actors, and that the state does not violate the rights of African Americans when it charters and licenses businesses that do. As private actors, discriminating against freed slaves, corporations and private businesses were deemed incapable of violating people's constitutional rights. For nearly 100 years, the decision stood as precedent, clearing the way for Jim Crow laws and greenlighting individuals and businesses to violate minority rights at will. American apartheid was legalized by the U.S. Supreme Court. Once again, private law immunized privileged property from public governance, and public law allowed private wealth to hold the people responsible for encroaching on its privileges. Having your cake and eating it too has never tasted sweeter for the property class. When political pressure forced the hand of the federal government to curtail racial discrimination in the 1950s and 1960s, lawmakers were reluctant to find constitutional reasons to do so. The Federalist descendants were committed to preserving the Constitution as a guarantor of the rights vested in privileged property, including elite privilege of committing unfettered social indecency. To quell increasingly violent protests, they were willing to regulate the violation of African Americans' basic rights as a business practice, but prohibiting private citizens and corporations from violating the unalienable rights of minorities would be inconsistent with the Federalist original intent. Congress turned to the Commerce Clause as a more palatable alternative. It was a strategy that avoided enforcing the constitutional right to equal protection of the law for everyone. Commerce Clause regulation of business practices involving minorities eventually could be repealed, unlike constitutional protections. The Voting Rights Act of 1965, recently under assault and partial repeal, is an example of this kind of regulated rather than unconstitutional discrimination. And so regulating discrimination did not end it. The U.S. Supreme Court has a long history of reserving Bill of Rights constitutional protections for privileged property bundled in the corporate form. Notoriously, it has allowed Congress to regulate social injustices against people through laws couched as commercial policies. Had the justices of the court reached a constitutional conclusion that unambiguously perpetuated racial justice, perhaps the nation would have avoided the continuing oppression of targeted racial groups. Instead, the court and Congress legalized discrimination by private actors, and then, when it was politically unavoidable to do so, regulated racism. To regulate, let's remember, is to allow under certain conditions. And so I'm going to move on to the next section, regulation, wealth shock absorber. Any thoughts or comments or questions at this point? Okay, I'll move on. Regulation, wealth shock absorber. Commerce Clause remedies for racial discrimination set the example for environmental and labor regulation. So it wasn't just going to be about racial discrimination that the Commerce Clause would be invoked when it came to the destruction of the natural environment and the destruction of laborers' rights on the job. The Commerce Clause was also invoked. Pigeonholing pollution and mistreatment of workers as matters of interstate commerce kept protection of the environment and the rights of workers within the realm of private law, where safeguards could be increased and decreased depending on commercial priorities and the shifting winds of political opinion. Privatizing decisions about the rate of allowable environmental destruction and the tolerable level of mistreatment of workers on the job required Congress to create an empire of unelected administrative agencies with authority to issue government permits and regulations. The permits legalize pollution, and the regulations define the maximum allowable protections for nature and working people. Both nature and labor are thus defined as commodities. The intended result is that the rights vested in property remain unscathed. In historical terms, this situation is ironic. Prior to the American Revolution, John Dickinson complained bitterly of the ministerial condescension of the empire towards the colonies and how the crown put the interests of a giant corporation ahead of the rights of British subjects. It looks like going overtime here again, doesn't it? I hate to do this. I'm willing to go on, but there are some sections left here. Perhaps we should pause at this section and pick up again next month on August 8th, so that I don't want to stretch this to the point of burdening your attention or your schedules. So,
And we did have this scheduled until 8:30. But to your point, if people are, at the end of their attention span and have other things to do, I'll leave that between you and them to sort out. But I just wanted to let you know that it was advertised until 8:30.
and I'm happy to do that. How are we doing? Everybody's energy is still good? We're good? Good. Okay. In that case, I'll push on. Okay. I was mentioning Dickinson, and he was actually complaining about the British system of what we now call administrative law, and they called it ministerial law. Sam Adams was just fomented and screamed about the idea of ministerial law, to have these ministers come in who weren't even part of the government. They were just appointed ministers who would then come in and govern the colonies and govern, when I say the colonies, I mean the communities, the towns and the counties within them. And Dickinson wrote that, quote, "The rights of free states and cities are swallowed up in power. Subjects are considered as property. Are we to be given up to the disposal of the East India Company?" So he named a specific company. "They would sacrifice the lives of thousands to preserve their trash and enforce their measures." And so he was very derisive of the administrative state. Following the revolution and the Federalist counter-revolution, regulation of antisocial commercial behavior got its start. In place of outright prohibitions against assaults on community well-being, Congress and the states created a whole legal universe of administrative agencies that act as buffers between the communities harmed and the wealthy perpetrators. The first institutional regulatory regime under the Commerce Clause dealt with the railroads as an interstate commercial activity. In 1887, Congress enacted legislation creating the very first federal regulatory agency, the Interstate Commerce Commission. It was publicly promoted to the public as a reasonable solution to rein in the power of the railroads with rules and guidelines. Despite what was said publicly, industry leaders understood that regulation would work to their benefit. Charles F. Adams, president of the Union Pacific Railroad Company, is quoted as saying, quote, "What is desired is something having a good sound but quite harmless, which will impress the popular mind with the idea that a great deal is being done, when in reality, very little is intended to be done," end quote. In 1893, then U.S. Attorney General Richard Olney assured the president of Burlington Railroad that there was nothing for corporate bosses to worry about. Quote, "The ICC is or can be made of great help to the railroads. It satisfied the popular clamor for a government supervision of the railroads at the same time that the supervision is almost entirely nominal. Further, the older such a commission gets to be, the more inclined it will be to take the business and railroad side of things. It thus becomes a sort of barrier between the railroad corporations and the people, and a sort of protection against hasty and crude legislation hostile to railroad interests," end quote. Regulatory agencies established after the ICC are no different. They have been erected as, quote, "a sort of barrier between the corporations and the people, and a sort of protection against local legislation hostile to corporate interests." And we're all familiar with that as we confront corporations who come into our communities wanting to set up shop and do harm. So the regulatory agencies protect privileged property from local democracy and against being governed directly by the people. The regulatory system has, in fact, erected a nearly impenetrable barrier between the people and their legal creations, the mighty corporations of today. And it is guaranteed that so long as citizens play along and seek relief from corporate assaults by turning to regulatory agencies, the privileges conferred on the property class will continue to go unchallenged. Today, people are denied access to justice by laws that demand they exhaust all regulatory so-called remedies first, before being recognized by the courts as having grievances relative to the violation of their rights. If we're to understand how the regulatory system is used by the wealthy minority to deny the people's rights of self-government, then we must be clear that regulatory law begins with a set of givens that are put beyond the authority of the people to amend. During the Progressive era, historian J. Allen Smith anticipated the undemocratic outcomes to be expected from the substitution of state regulation for local self-governance, saying, quote, "Satisfactory regulation is not, as seems to be implied in much of the discussion favoring the substitution of state for local control, merely a question of placing this function in the hands of that government agency which has most power and prestige behind it. The power to exercise a particular function is of little consequence unless there is an adequate guarantee that such power will be exercised in the interest of the local public for whose protection it is designed. It should be lodged in some governmental agency directly responsible to the constituency affected. But of course, our regulatory agencies are not responsible to the communities in which the permits are issued to the corporations. Regulatory schemes presume the legality of harms inflicted in the course of profit making. Administrative law places minimal restrictions on profitable activities that damage communities and the environment, and legal expenses resulting from litigation against their damage to communities are tax deductible as business expenses for corporations. Not so for community organizers and local governments. And that, again, is an instance of corporations as privileged property, that they can deduct the cost of defending themselves against violating the rights of communities, while communities cannot deduct the expenses of protecting their rights. Bureaucratic permitting process effectively strips states, counties, and municipalities of the authority to govern antisocial commercial enterprises. It's no different for workers' rights than it is for communities or the environment. Regulation of labor issues as commercial activities rather than as matters of human rights means that the relationship between people who work and people who profit from their work will reliably support minority profiteering at the expense of the majority. The regulations don't put businesses on notice to behave well. They put a government bureaucrat between the worker and the employer as a buffer, letting lawmakers keep an active hand in deciding labor issues as matters of commerce ensures the rights of working people remain negotiable and alienable and not unalienable. Gradually, it has dawned on reformers that the regulations they fought so hard to get have limited effect. The rights of corporations to unfettered interstate commerce and their contractual immunity from interference by state government inoculate employers from having to respect the rights of workers. Because they aren't constitutionally protected rights, statutory protections can be eroded and discarded. Unlike corporations, working people and the environment have nothing comparable to the Commerce Clause to trigger private law that works exclusively to protect their rights. When they engage in what the law calls commercial activities, people disadvantaged for lack of privileged property are at the mercy of legally weaponized wealth. Supreme Court sophistry over so-called private actors and so-called state actors proves the point that under US law, rights vested in property can negate human and civil rights. Simultaneous with the invention of a public sector and a private sector came the establishment of a two-track system of law. Wealth is protected like an unalienable right, while unalienable rights of people are treated as negotiable, and the loss of rights on the job as concessions and compromises that workers have permission to waive in defense, in deference, I should say, to economic priorities and to secure a job. The solution to this mess is to protect unalienable rights through bedlock constitutional protections and to subject state-chartered corporations and businesses to the governing authority of the people at all levels of government, especially at the community level where corporate harms will be felt directly. The US Constitution and the laws derived from it forbid this solution. And moving to the next section, possession is 9/10 of the law, the mathematics of injustice. The Northern Federalists got their Commerce Clause by agreeing to concessions with the Southern slaveocracy. Those compromises included the most startling example of injustice to be sewn into the US Constitution. Enslaved humans were made into a kind of privileged property. They became reservoirs of political power transferred from the people at large to plantation aristocrats. The Federalists attached powerful governing privileges to ownership of human property in the grammatically awkward 3/5 clause of the Constitution. And I'll leave it to you to look it up and read it. When I say it's grammatically tortured, it's almost incomprehensible, but there it is. The Contracts Clause is essentially says that the states may not interfere with the obligations of contracts. So once a contract is written, that is private law, and the public government can't interfere. By vesting a right to superior political representation in enslaved human property, the Federalists knew they were indirectly elevating a host of wealthy men above all other Americans. The number of votes in the House of Representatives and the Electoral College allotted to each state was determined proportionally by population. The enslaved would be counted as 60% of a whole human being in the census. Slave owners got an additional say in Congress and the White House by counting each natural person owing their future labor to them as 60% of a person. The Federalists gave disproportionate control of the House of Representatives and the Electoral College to owners of privileged property. Moving on, wealth turns other people's work into property, the true nature of servitude. The last paragraph of Article 4, Section 2 in the U.S. Constitution tells Americans that, quote, no person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. A little aside, this language is somewhat similar to what the Congress did when they changed the bankruptcy laws to disallow students from declaring bankruptcy and getting out from under the crushing debt that they incur when they borrow to get their degrees. So to protect the rights conveyed through property to slave owners and creditors, the Fugitive Labor Clause voided these unalienable rights: the right of enslaved people and debtors to due process of the law. On a mere property claim, the liberty of an accused slave or debtor was forfeit. Also, the rights of enslaved humans and debtors to life, liberty, and the pursuit of happiness, including ownership of their own bodies, minds, and the work they produce. That was lost to the Fugitive Labor Clause. And finally, the right of local community self-government, specifically the right of individuals, states, local governments, and communities not to support slavery and involuntary servitude by obeying this part of the Constitution, even in states that did not recognize slavery as a legal commercial enterprise. They were forced to cooperate in the return of indentured servants and enslaved Africans. In 1865, the 13th Amendment banned slavery and involuntary servitude. It didn't utterly gut the last paragraph of Article 4, Section 2, but only those parts specific to slavery. A creditor's claim to ownership of a debtor's future labor was deemed a legally protected form of privileged property. By not touching this aspect of the Fugitive Labor Clause, the 13th Amendment preserved the rights vested in property as superior to the human and civil rights of debtors and laborers. The Fugitive Labor Clause was rendered moot as it applies to slaves and debtors fleeing to so-called free states, but its underlying principle that to protect rights conveyed through privileged property, the rights of the people to own their own labor had to be nullified. The core tenet of the Federalists that a debtor's labor belongs to the creditor wasn't repealed. And today we have a generation of people indentured through student loans, stripped of legal recourse to bankruptcy, owing a fair chunk of their productive years to people happy to receive a cut of their paychecks as pure unearned profit. And moving on to the Contracts Clause, more specifically, a gentleman's agreement to usurp the people's sovereignty, contracts uber alles. To further limit the authority of the states and local governments to interfere with commercial and financial transactions, the Federalists included the Contracts Clause in the Constitution, which reads, no state shall pass any law impairing the obligation of contracts, as I kind of paraphrased earlier. Like the Commerce Clause, this language seems innocuous and simple to modern Americans. We're conditioned to accept it as a given that bilateral business and financial agreements are outside the scope of general governing authority. But together, the Commerce Clause and the Contracts Clause have the effect of elevating wealth into the pantheon of unalienable rights protected from meddling by an unsympathetic mob. Contractual arrangements are often a ploy for wealthy parties to impair the obligations of the social contract agreed to by every American who submits to the rule of law. Through non-disclosure agreements, First Amendment rights are privatized. Through out-of-court settlement agreements, the right to a jury trial is forfeited. What is lost when the jury is kept out of out is the people, the commoners, and the community. The same goes for mandatory arbitration. Non-disclosure agreements and intellectual property rights waivers as conditions of employment force commoners to barter for their First and Fifth Amendment rights for the privilege of earning a wage. The immunity of contracts from public law makes it possible for private law to serve the rights vested in property while the rights of people go unprotected. Meanwhile, the court's unchecked power to interpret the Constitution and laws in consistently wealth advantaging ways has grown exponentially. The Supreme Court retooled the Contracts Clause in 1819 to destroy any remnant of local autonomy and self-government even more intentionally in order to protect the rights vested in property from democracy. And it's to that story that we'll turn in part 5, where the Contracts Clause is used in order to strip municipalities of their power of self-government, and the people who live within the jurisdiction of municipalities to strip them of their unalienable right to self-government at the community level. And that is a story that is really worth paying attention to. I hope you'll be here for it on August 8th, because it explains an awful lot about why it's so, well, not only difficult, but illegal for communities to say no to pipelines and toxic landfills and all kinds of other harmful corporate profit-making schemes. And understanding that is, I think, extremely important to the kind of organizing and the kind of resistance to corporate overtake of government that is not only ongoing, but accelerating today. And I'm going to wrap it up there for today and ask if there are any final questions, comments, concerns, thoughts, anything. Doug.
Hey, Ben, thanks a lot for that. I came late, but it's something that's been thinking about how do we, I mean, we have to go through these legal arguments in court and so on. And a little while ago, somebody sent out some kind of some kind of posting about this guy from Harvard, and he was a law professor, and this woman was on, I think it was Bad Faith or something like that. But it brought really to my clearly to my mind that there's got to be another way in which to drive at why we're not, where, in other words, my real question is, where does our consent come into being enabled to do what it's supposed to mean? We have to be able to give our consent to something that we go against, but a regulatory system doesn't even have to answer to it. And I asked a representative about it, and they said, well, through our representative government, they gave the consent for us. So there's a little niche right there. But if we could prove the damages of being polluted and the harms and its effects, the first thing the judge has to see is that was there consent? Because if you gave them consent to go along with the project, you don't have any bearing on how you can.
Let me pause you there, Doug. We're about out of time, but just to say, yeah, the presumption is that we vote for and elect our representatives, and then when our representatives agree to create these regulatory agencies, they are representing our will, our consent. So we're not going to get anywhere arguing that they didn't come specifically to us and get our consent, because the courts regularly take for granted that your representatives speak for you and they express your will. We know that not to be the case. And later on, when we get to part 8 of this series, the chapter we'll be talking about is titled The Pretense of Representation. The pretense of representation includes all kinds of things, but we're familiar with some, like gerrymandering. The idea that the candidates and the parties choose the elector, the voters, rather than the voters choosing their candidates. And there are a lot of other techniques where representation is skewed, and it actually doesn't exist for us, for the majority. It exists for the wealthy, for the corporate class. We're going to get into that eventually. So unfortunately, I can't, just kind of download all of it in one sitting here. But, and as you can see, it takes an hour and a half to get through a chapter, really. But yeah, we will touch on that. But I don't believe strategically going to gain any ground by pursuing the lack of consent as our central argument, because the presumption of the courts is, well, you gave your consent when you elected this representative. And beyond that, the court is going to presume a lot of other things that we wouldn't necessarily agree with, but we don't have the option of disagreeing with, because they're law, they're precedent. And precedent, by the way, is the tool used to uphold and hang on to the status quo. And if we're trying to change the status quo, we're blocked by precedent. So it's a catch-22 kind of a situation. Anybody else?
Just add to that. Here's folks who are well-meaning, Page and Gillen, that was, I guess. There's an implication here, what has gone wrong about democracy? What can we do about it? Which is, part of what you're saying here is like, it's been wrong, number one, but number two, they do the data surveillance checking, et cetera, and so on, and found that, yeah, less than 1%, to Doug's point here in your description, less than 1% of actual people actually have any influence whatsoever.
That's right. Yeah,
that's what they've come up with, real data, not, hey, that seems like, no, it's how it works.
There is real data that shows that about 1% of what the majority of people want ever is enacted, while a large percentage of what the corporate folks want becomes law. And there's a reason for that. There are numbers of reasons for that. And what I call privileged property is one of them. Because, and I mean it literally, that the owning that wealth and owning those wealthy corporations conveys the authority to govern to the owners, so that the government we say is our U.S. government is actually their U.S. government.
Mm-hmm. It was, I believe, for a while that neoliberalism and all these sort of methods of naming what's going on had to do with wealthy people getting rid of government. No. They need the government. That is what supports their laws that they themselves, through their lawyers, have created. It's
when I first started doing this, the community organizing, it puzzled me why corporations that didn't like the local laws that we were writing didn't just violate them, didn't just go, we're not going to pay any attention. They never violate them. Why is that? Never, ever. What they do is they sue to overturn them, and they take them away from the community, but they never violate them because, in fact, law is their tool. They're not going to say, we don't believe in law, because law is the very thing that forces us into compliance and into obedience and into
supported.
Yeah.
State. Yeah. It's called, regulatory capture?
It's regulatory capture when they control, the EPA or your state
the regulations are made by them.
But it is congressional capture and Supreme Court capture and executive branch capture at this point.
There you go. Touché.
And which may lead you to wonder, all that's going on with the indictments of the former president and all of that. Look how horrible this guy is and what he wanted to do. He wanted to do it, but when you really get down to it, all he wanted to do was put the icing and the candles on the cake.
Yeah, I often told some friends before he's even in, I said, well, he's not the problem. he's a symptom of how we've come to be able to elect him for the folks who were really disenfranchised when the corporation said, hey, we're not making enough money, and off they went.
He's
And
certainly
more
a
people than
problem. And certainly there'll be a lot of energy and emotion expended, hoping and praying that he is kept out of office and maybe incarcerated. And yet I've seen this throughout the history that I've kind of explored. I've seen what happens is that when things are looking like they're really getting bleak and things are just getting authoritarian like crazy, there'll be a, oh no, we aren't going to do that, and to stop, and everybody stops and breathes a sigh of relief, like we've been saved. When in fact, what's been saved is the status quo, because up until this crisis of government, there's been a lot of energy, a lot of pressure building up of people saying, we got to fix it. You can't keep dumping on us, whether it's in the workplace or environmentally, or when it comes to the rights of women or gays or whatever it is. There's all of this energy going into saying, we've got to reform all of this. And what happens? Authoritarianism comes in and says, oh, we're going to really take over. Now instead of demanding all the things we demanded, we're going to accept the crumbs we get because at least we didn't get the worst. I mean, that is a recurring theme throughout the country's history that you should look into. We are now a bit over time, and I will say thank you for being here. Remind you to register. Again, go to the CELDF website. Along the top banner, there's a pull-down menu. Put your cursor over it on resources. There'll be two columns. In the left-hand column, it says How Wealth Rules. Click on that, and now you'll be on the page. You can scroll down and hit the register button if you'd like to join us for our August 8th installation of Section 5. And I hope to see you there.